force. From the national reckoning sparked by the murder of George Floyd to the recent highly publicized encounters involving immigration agents, there's a significant need for more clear, factual information on how the law actually operates. These moments often spark deep public outrage and intense debate, but they also highlight a significant gap between public perception and the legal reality of the badge. We are joined today by Professor Christopher Zaleski to help us better understand the legal realities of this complex issue. Christopher Zaleski brings over 2 decades of field experience to the exchange. A graduate of the FLETC Police Legal Advisor Program, Chris has served on the front lines as a state law enforcement officer and at the peak of agency leadership as the chief probation officer of Denver County Court. Whether he was helping to manage a $1 million Second Chance Act grant or collaborating on the Greater Newark Safer Cities Initiative alongside the late George Kelling, Chris has spent his career at the intersection of operational reality and systemic reform. As the department chair of criminology at the Chicago School, Professor Zaleski integrates evidence-based research and legal theory to help his students and other practitioners navigate complex real-world case studies. He's here to provide the historical and legal framework necessary to understand how the justice system evaluates these critical moments. Please join me in welcoming Professor Christopher Zaleski.
Good evening, everyone. Grace, thank you so much for the introduction. I'm excited to see that you're graduating really soon and continuing your education. Well, tonight I'm going to be sharing some videos that have sound and they have a little bit of some graphic depictions. They aren't too graphic, but they're going to show you some serious situations related to police using deadly force. This is a very important topic, and we've seen these types of videos before on TV and social media. So, yeah, we're going to get into it. If you have questions, please put them in the Q&A section. You can write some stuff in the chat as well. I'll try to look at that as we're going, and I'll answer questions at the end. But we have a lot to go through. We're going to talk a lot about how police use force. It's kind of a complicated thing. There's some case law out there. There's some policy out there we need to look at. So, yeah, we're gonna get right to it. So, why is this topic really that important to include in a exchange like this? Grace started talking about this, but over the last several months, our social media feeds and news cycles have been dominated by these high-profile police shootings caught on video. We've seen intense media commentary and public tension following deadly encounters involving ICE and protesters. When these videos go viral, they're often framed through the lens of public opinion, right, or a political narrative. Tonight, we're going to step out of that narrative of speculation, and we're going to go into the courtroom. We're going to set the record straight on what the law actually says regarding the police use of force. Now, my perspective tonight comes from my time as a law enforcement officer, as well as a licensed attorney and my training as a police legal advisor. As a law enforcement officer, as a police legal advisor in my past, I didn't have the luxury of navigating the public tension, right? I had to navigate the Fourth Amendment, our Constitution. The justice system does not evaluate a critical incident based on how it looks on a cell phone video. It evaluates it based on a rigorous legal framework. Our goal tonight is to provide you with the factual roadmap of that framework. We'll begin with a deep dive into the Graham standard and the definition of objective reasonableness. But more importantly, we're going to analyze how the legal landscape shifted just this past year. For decades, many courts relied on this moment of threat doctrine, focusing only on a split second the trigger was pulled. But in 2025, the Supreme Court unanimously said in Barnes versus Felix, they overturned that and said that we're not going to look at the moment of threat. We're going to discuss why the law now requires a totality of the circumstances review, allowing us to evaluate the conduct and decisions an officer made leading up to an encounter. So I think it's important to start with this. We see police using force, right? But sworn law enforcement officers have been granted the extraordinary authority to use force when necessary to accomplish lawful ends. So we employ these folks as government agents, and we grant them this authority, this extraordinary authority to take people's lives when necessary. That's an important word there, when necessary, right? And it is law enforcement's obligation to prepare individual officers in the best way possible to exercise that authority. So police have a duty to act. And in instances where there's the threat of death or serious bodily injury to somebody, retreating by police may cost them their job. It could cause people to lose their lives since they have that duty to act, right? So they could be brought up on charges, they could be sued. So they're going into these situations not planning to retreat from them when danger is presented in front of them. So I'm going to show you a video here, and it does not have any sound, the first one. And I just want you to take a look at it. And I want you to just take in everything that you see. Keep a close eye on the details if you can. It's just it's like a minute or two long, if that. This one does have sound. So in this video, you're seeing this person get what appears shot by police, right? So I want to ask you, was the use of deadly force here justified by these officers? What do you think? You can put it in the chat what your thoughts are on this. You can pick A, B, C, or D. Yes, the police were justified in using deadly force here. B, yes, but the police can only shoot at his leg, so they shouldn't be using deadly force. No, police can only tackle him or use other less lethal force in this type of situation. Or no, police are not authorized to use deadly force in this type of situation. I'm curious what you think. Yeah, I'm seeing some stuff about I need more information, right? But a lot of folks are picking C, right? So we're looking at that video going, something doesn't look right, right? It looks like the police are just shooting this guy who's walking there, right? He looks like he might be unarmed. He looks like, why does he deserve, why would police be able to be authorized or justified to shoot somebody here, right? And these are the types of videos that we see all the time on social media. And police departments are saying, we have no comment right now. Things are under investigation. We can't comment until the investigation is over or we get more information. But yes, someone leaked this cell phone video or someone leaked this the body camera here, and this we have no further information. Well, what happens is the public fills the void, right? They're talking about this, and everybody is analyzing it and saying police had no right to do this. This is what happened here. We don't always have the full picture. We don't always see everything. I want to show you a little bit more of this video. The second video, this one I'm sharing, has no sound. So we're just gonna see what we can see here and talk about it here in a second. So we see a bit of a different picture here, don't we? Now that we've seen more video, it really has changed, right? And so I'm curious, I have another question. Now that we know a little bit more, when do you think the first officer you see in the video clip, when could they have actually used deadly force? Do you think it's A, as soon as he sees the gun pointed at another officer? B, as soon as the suspect walks away with the gun in his hand? C, as soon as the suspect turns and fires at officers? Or do you think that deadly force here was not justified? I'm seeing a lot different answers, right? I'm not seeing that C answer we saw before. I'm seeing a lot of folks saying A, B, or C here, where we're saying it's justified the officer could use force, right? This is a big difference than what we saw in that first video because we didn't have the whole picture before. So before we as civilians, before as we as consumers of information see something, we should not be jumping to conclusions. We need to see what the full picture is. And I'm seeing stuff even too, like, it shouldn't be deadly. It should be, something else besides deadly force, maybe. Okay, let's look at some options as we talk about things here tonight. So we're going to get into this. When we talk about police use of force training for officers should really be threefold. It should focus on law and policy, and that's all we're going to talk about tonight. We're going to talk about the U.S. Constitution, whether they're state constitution or case law, and then state policies or departmental policies. That's the main thing, right? This is where we can start from. And then based upon what the law and the policy is, then it's going to affect our decision making. That officers could create thresholds, they can have practical exercises to better understand how to deal with threats. And then tactics and range exercises, right? Officers need to know how to use their weapon, not just qualify and pass. They've got to be able to practice using it. There's some tactical training. All of those pieces need to go into use of force training. But what we're talking about tonight is law and policy. There is no one policy out there. Each department has their own policy. It is based upon what the law of the land is, what the Constitution says, based upon what the Supreme Court has said. We're going to look at those Supreme Court cases tonight. Based upon that, based upon if there's any other further restrictions in any state constitution or any state law or state policy, a department will create their own policy for their officers. So there is a national consensus policy out there. That's an example that many agencies might use. They might use some of it, they might use all of it. And you can see these different, the FOP, the International Associations of Chiefs of Police, CALIA, there's a whole bunch of agencies that endorse this and say, we came together to put this national consensus policy. We think this is the best policy, but again, this is a national type of look at it. Each department may have different policies based upon the tools that they have available to them. Some departments, they don't have tasers or they don't have batons. Some places you can't, hit a car and hit a car. You can't get into a pursuit. There's all these different policies. So policies are going to be different per agency. But we start with the U.S. Constitution. We look at the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So there's some really important words in there. And if you ever take a criminal law class, you're going to talk about these things in this class. But there's that word probable cause and unreasonable searches and seizures. Stopping somebody from moving, whether it's, if I'm that officer and I put my hands on you to stop you from moving, I am seizing you. You're not free to go. If I put my handcuffs on you, if I have to hit you with a baton or shoot you with a taser, I am detaining you, I'm seizing you. And the most extreme seizure is me shooting you, employing deadly force is the ultimate seizure. So that all falls under the U.S. Constitution, under the Fourth Amendment. So tonight we're going to talk about these three main cases: Graham versus Connor, Tennessee versus Garner, and Felix versus Barnes. So Graham versus Connor, that's the leading case on use of force. It's from a 1989 Supreme Court decision. And the court held that all claims that law enforcement officers have used excessive force, so this was about excessive force here, whether this force was deadly or not, in the course of an arrest, a stop, or any type of other seizure of a citizen, it has to be analyzed under the Fourth Amendment and its objective reasonableness standard. So that's where we're starting with things. So let's talk about what a seizure is, okay? The court says that a seizure occurs when a law enforcement officer terminates a free citizen's movement by a means intentionally applied. An officer may seize a person in many ways. Traffic stops, investigative detentions, and arrests are all seizures under the Fourth Amendment. To seize someone, an officer may yell, "Stop." The officer may use handcuffs, a baton, a firearm to make the suspect stop. Every seizure must be objectively reasonable, meaning reasonable as its inception, in the manner it was effected and in its duration. So from the beginning to the end of an incident, we have to act reasonably, objectively reasonably. Talk about those words in a moment here. So let's talk a little bit about this Graham case. Let's get in a little deeper. So on November 12th, 1984, Graham, who is a diabetic, he felt the onset of an insulin reaction. He asked a friend of his, William Berry, to drive him to a nearby convenience store so he could purchase some orange juice to counteract the reaction. Well, Berry agreed, but when Graham entered the store, he saw a number of people ahead of him in the checkout line. Concerned about the delay, he hurried out of the store and asked Berry to drive him to a friend's house instead. Connor, an officer of the Charlotte, North Carolina Police Department, saw Graham hastily enter and then leave the store. The officer became suspicious that something was amiss, and he followed Berry's car. About a half mile from the store, Connor makes an investigative stop. Although Berry told Connor that Graham was simply suffering from a sugar reaction, the officer ordered Berry and Graham to wait while he found out what, if anything, happened at the convenience store. When Officer Connor returned to his patrol car to call for backup, Graham got out of his car, ran around it twice, and finally sat down on the curb where he passed out briefly. So in the ensuing confusion, a number of other Charlotte police officers, they arrive on the scene in response to Officer Connor's request for backup. One of the officers rolled Graham over on the sidewalk, cuffed his hands tightly behind his back, and ignored Berry's pleas to get him some sugar. Another officer even said, "I've seen a lot of people with sugar diabetes that never act like this. Ain't nothing wrong with this motherfucker but drunk. Lock the son of a bitch up." Several officers then lifted Graham up from behind, carried him over to Berry's car, and placed him face down on its hood. Regaining consciousness, Graham asked the officers to check in his wallet for a diabetic decal that he carried, and in response, one of the officers told him to shut up and shoved his face down against the hood of the car. 4 officers grabbed Graham and threw him headfirst into the police car. A friend of Graham's brought some orange juice to the car, but the officers refused to let him have it. Finally, Officer Connor receives the report that Graham had done nothing wrong at the convenience store, and the officers drove him home and released him. At some point during this encounter with the police, Graham sustained a broken foot, cuts on his wrist, a bruised forehead, and an injured shoulder. He also claims to have developed a loud ringing in his right ear that continues on to the day. So what happens? Of course, Graham is going to file a lawsuit against individual officers involved in this incident, alleging that they had used excessive force in making this investigatory stop in violation of his rights secured to him under the 14th Amendment to the United States Constitution. That's what he said. This is against my rights under the 14th Amendment to the U.S. Constitution. So, go back here. So I want to see what you think. Was the use of force by police here reasonable or excessive? What do you think? When you hear what happened to Graham, would you say that this was excessive or reasonable? A, the police were excessive in their force. B, police were reasonable in their force. Or C, maybe you're not sure. I see a lot of answers of A, that the police were excessive in their force. Well, let's look at what the court said, and let's see if you agree with them or they agreed with you. So he files a lawsuit. There was excessive force, right? He loses. The district court looked at 4 factors, including the extent of the injury and also whether the force was applied in a good faith effort to maintain and restore discipline, or maliciously and sadistically for the very purpose of causing harm. I don't think we could say that the police here were being malicious or sadistic just to cause him harm, right? So that's what they looked at. And the district court said, we're throwing this out. There was nothing done malicious or sadistically. There were some mistakes here. This is not excessive force. So what do you think happens next, right? Graham appeals, and it goes to the Fourth Circuit Court. The appeals court agrees with the lower court. So what happens next? Well, Graham appeals to the U.S. Supreme Court. This is what the court says. All claims that law enforcement officials have used excessive force, deadly or not, in the course of an arrest, investigatory stop, or other seizure of a free citizen or property analyzed under the Fourth Amendment, right? We talked about this before. It's not under some maliciousness. It's about objective reasonableness standard rather than any kind of substantive due process standard. So the Fourth Amendment reasonableness inquiry is whether the officer's actions are objectively reasonable in the light of the facts and the circumstances confronting them, without regard to their underlying intent or motivation. So we don't care if they were trying to be sadistic. They could be, but we don't care about that. We're wanting to know if their use of force was objectively reasonable in this case. And the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene. And its calculus must embody an allowance for the fact that police officers are often forced to make split-second decisions about the amount of force necessary in a particular situation. So further, it says, the court says, our Fourth Amendment has long recognized that the right to make an arrest or stop necessarily carries with it the right to use some degree of physical coercion or threat thereof to effect it, right? So if you've studied any other law and you had a criminal law class, you might have talked about Terry versus Ohio, a Terry stop, right? A detention, making sure somebody can't move. They're not under arrest, but they're being detained. So the court says that we know that if you're making an arrest or some kind of stop, it probably comes with some type of coercion, like, hey, you move, I'm going to push you down. I'm going to put you in handcuffs. I'm going to chase you. You run, I'm going to do something else. If you fight back, we're going to fight back with you, right? So they're saying we recognize that. And the reasonableness must be judged from the perspective of a reasonable officer on the scene rather than the 20/20 vision of hindsight. So the calculus must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. So we have the court here acknowledging that cops make split-second decisions. They are often involving in rapidly evolving incidents. And so reasonableness has to come into play with the amount of force necessary. Again, that objective reasonableness, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 hindsight. So there is no 20/20 hindsight in this objective test. When a plaintiff sues a defendant, like Graham here suing Officer Connor, the plaintiff, Graham, may make several complaints about the seizure, right? Graham could allege that Connor's decision to stop the car was unreasonable. Next, he could complain about the handcuffs and the way he was placed in the cruiser. In short, Graham could complain about the seizure was unreasonable in so many ways, at its inception, in the manner that it was effected, or in its duration. But again, officers are judged based on the facts that are reasonably known to them at that time. When they learn, what they learn later is not relevant. And what was not available to those officers when Graham was initially stopped, handcuffed, and put in the cruiser was the report from the officer who returned to the store. Nothing was actually amiss, right? But officers didn't know that. But knowing that now would be judging the officers based on 20/20 hindsight. And the Supreme Court specifically rejects that type of test. So when is force reasonable, right? We must balance the nature and quality of the intrusion on the individual's Fourth Amendment interests against countervailing governmental interests at stake. So what did the officer do? And why did the officer do it? Those are the questions, right? The more intrusive the seizure, the stronger the governmental interest should be, right? So Connor, for example, stopped Barry and Graham by activating his police car's overhead lights. And no doubt, an investigative detention here like this intrudes upon a citizen's liberty. They are inconvenient. They're often embarrassing when people get stopped. But the government also has an interest in investigating criminal activity. Investigative stops are reasonable when an officer can articulate facts to support them. And in this case, the intrusion on Graham's liberty became much greater after that vehicle stop, right? But a reasonable officer might say, we had a great governmental interest at stake to investigate crime. Courts will look to 4 factors from the Graham decision to find the governmental interest. And no single factor should be considered in a vacuum. So what are these 4 factors that we have from Graham? Well, 1, the severity of the crime at issue. 2nd, whether the suspect posed an immediate threat. And 3rd, whether the suspect was actively resisting, right? Whether the suspect was actively resisting or trying to evade arrest by flight. So let's apply the facts to the factors. What was the severity of the crime here, right? Officer Connor may have been acting under a reasonable suspicion that Graham stole something from the store when he activated lights in the cruiser. If there were facts that Graham committed an armed robbery, right, Connor may have used a more intrusive means to stop Graham and Barry, such as having maybe more police units there before the stop, taking them out at gunpoint. That didn't happen, right? But generally, the more severe the crime, the more intrusive the force option may be. So not as serious, seems like a minor intrusion to stop the vehicle. In looking at this case, you might even just be saying, like, wow, case is just crazy. How bad are these police officers? This guy was diabetic, right? But these are things we know now. We're looking back to it. So was it reasonable to stop and investigate Graham and Barry? That's what we're asking, right? What might be reasonable for these officers to write in their police reports? What might we have seen Connor write in his use of force report? He might have said, I saw Graham run into the store. Less than 15 seconds later, I saw him run back out and get into Barry's car. I heard the tire screech as the car drove away at a high rate of speed. And an officer's training and experience is also relevant. Connor might even add, based on what I saw, and my department having received no less than 4 complaints of shoplifting from this store within the past 2 weeks, I activated my overhead lights and Barry pulled to the side of the road. Connor would be admitting here to effecting a Fourth Amendment seizure. But again, a Terry stop is reasonable if Connor can point to specific articulable facts that criminal activity is afoot. That's Terry, right? It should be obvious by now that the officer must help the court visualize what happened. Using good action verbs in a written report makes this visualization possible. And Connor might go on and further write, after Barry stopped, I walked to his car. I saw Barry behind the wheel. I saw Graham seated in the passenger side. I told both of the men to wait in the car. I ordered another officer to go back to the convenience store to find out what happened. That kind of all sounds reasonable at this point in time. Then Graham got out of the car. Graham opened the passenger door. He ran around the car 2 times. Then he sat down on the curb and fell over as if he had passed out. And personal beliefs or conclusions are generally appropriate if they're supported by facts. Connor here might say, I believe that Graham was under the influence of alcohol because I have seen many people who are under the influence of alcohol or narcotics. They are generally irrational. Graham was irrational here. He ran around the car 2 times, and I, as a police officer, told him to wait in the car. Then he sat on the curb and fell over, as if he passed out. Connor might even say Graham's eyes were glassy. His speech was slurred. His breath smelled sweet, like alcohol. Referring back to his training and experience, Connor could explain why intoxication is relevant. He could say, I know that over 80% of the assaults on police officers are committed by people under the influence of alcohol or narcotics. But unsupported conclusions are not relevant. Without facts, statements like Graham appeared drunk or he posed a threat to me are nothing more than the officer's subjective beliefs. So when police write the reports, they can't just have these conclusions. These conclusions play no part in the fact-bound analysis of whether an officer's actions are objectively reasonable. They have to be supported by facts. So when we look at number 2 here, was the suspect an immediate threat? Whether the suspect is an immediate threat to the safety of officers or others is generally considered the most important Graham factor. The general rule is the greater the threat, the greater the force option. For example, vehicle stops do pose a threat, right? That's a fact. There are a lot of unknowns. To control the scene, an officer may use reasonable force to control the movements of the driver and passengers. Again, a reasonable officer could believe that the governmental interest became much greater after the vehicle stopped. Officer Connor told Berry and Graham to wait in the car, but Graham got out, and his failure to comply to the evidence of Graham's add to this his failure to comply to the evidence altogether that Graham, what the officer believed here was obviously intoxication, right? And a reasonable officer might believe that Graham posed a threat to Officer Connor, to other motorists on the adjacent street, and to Graham himself, right? So what could a reasonable officer do? Was it objectively reasonable to handcuff Mr. Graham, to put him in the back of the patrol car under those facts and circumstances? So we're looking at these factors here, right? So we know what the severity of the crime is. It's pretty low here, right? But we have some type of crime. And was he an immediate threat? I don't know. We're at a motor vehicle stop here. He's getting out of the car. We can control that person, especially when an officer told me he needs to stay in the car. And is the suspect resisting arrest, right? Resisting arrest or other lawful seizure, it affects several governmental interests. During an investigative detention, it hinders the officer's ability to investigate the crime. It may put the officer trying to control the suspect at risk, and it may endanger members of the public who get in the way. Graham's failure to obey Connor's order to stay at the car could affect all three. And here, was the suspect fleeing from a lawful arrest? Well, like resistance, attempting to evade an arrest frustrates several governmental interests. The general rule is that the more serious the crime, the greater the governmental interest in stopping the suspect, and the more intrusive the seizure may be. And there's some other factors. The Graham factors are not a complete list, but while other lower courts have listed others, most are a subset of what is generally considered the most important, right? That threat to the officers or others. So for some examples, courts have considered the number of suspects versus the number of officers as affecting the degree of threat. So does the size, the age, and condition of the suspect confronting the officer. The duration of the action is important. Just consider how exhausting it is to wrestle someone for 2 to 3 minutes. What if an officer knows the suspect has a history of violence or assaulting law enforcement officers? There are some other factors that do not fall neatly under the Graham, but do flow naturally out of the court's decision here. The degree of injury suffered by the suspect and plaintiff here seems relevant in light of the court's guidance that not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers, violates the Fourth Amendment, they say. So in a case where the plaintiff alleges that his handcuffs were too tight, the court may examine the plaintiff's actual injuries and whether the plaintiff complains so the officer could correct the problem. Other circuits, such as the Ninth Circuit and the 11th Circuit, discuss the need for the use of force, particularly in cases where officers use intermediate weapons like batons or tasers or pepper spray. It is the need for force which is at the heart of the Graham factors, says the Ninth Circuit. And time. Time is a factor. Since not every encounter requires a split-second decision, the reasonable officer might say the more time to choose a force option, the more reasonable it should be. A robbery suspect who reaches into his waistband creates some split-second decision-making for the officer. More deference should be given to the officer's decision there. But not every situation requires this split-second decision. Consider someone in crisis who grabs a metal bat. If he doesn't pose an immediate threat, there is probably time to consider other, less intrusive options. This kind of even takes us back to our conversation on Monday about more effective police approaches to mental health crises, right? So when we say reasonable officer, we are not comparing all officers. So for example, if a specially trained marksman can shoot a suspect from 1,000 yards away, but the average officer can't, we're not judging every officer at the scene like a marksman, right? Since the objective test judges the officer through the lens of a reasonable officer, the subjective beliefs of the actual officer, whether they are good or bad, are not relevant. Facts make force reasonable. The objective reasonableness test requires officers to rely on their senses. What did they see? What did they hear? What did they smell? What did they taste? What did they touch? And then articulate a factual basis for the seizure. Was the seizure reasonable? Meaning reasonable at the inception, in the degree of the force used, and in its duration. So that's Graham. Let's also fill in some blanks here with this case, Tennessee versus Garner. This happened a little bit earlier. Graham happened in '89 was the case from the Supreme Court. Tennessee versus Garner was a few years earlier. In this case in particular, it asks, when is it reasonable to use a firearm? The Supreme Court's decision in Tennessee versus Garner provides some good examples of when a police officer may use a firearm to seize someone. The Garner case started with a complaint about a burglary in progress. Two police officers, they respond to the scene. One of them sees Garner, the suspect, run out of the house. The officer described Garner as a 17 or 18-year-old male, about 5'5" or 5'7" tall. The officer saw no sign that Garner was carrying a weapon, and based on the facts, was reasonably sure he was not armed. Well, the officer yells, "Police, halt!" But Garner keeps running away. When Garner began to climb over a fence, the officer had two options. He could let Garner escape, right? Or he could use deadly force to stop him. Relying on a Tennessee statute at the time that allowed police officers to use all necessary force to effect the arrest of a fleeing felon, the officer did what he deemed was necessary at the time. He shot Garner in the back of the head, and Garner died in the operating table. So at this point in time, when this officer was using this deadly force, there's a Tennessee law that says, officers, if you have someone who is fleeing and they're a felon, so if we suspect you're right, a burglary in progress, a burglary is a felony. So we have someone fleeing the scene of a felony, a burglary. So they're authorized by state statute in Tennessee to use all necessary force to stop that person, to arrest them. So this officer thought they're doing everything they're supposed to be doing under the law, right? Well, Garner's family sues and says, I don't think that that's right. I don't think they should just be shooting somebody. There was no weapon. Even the officer said, I'm reasonably sure that he's not armed. I don't see a gun. Yep, but I'm using the statute as what I need to do to stop this guy. So in Tennessee versus Garner, the Supreme Court held that the Fourth Amendment prohibits the use of deadly force to prevent the escape of a suspected felon unless the suspect poses an immediate threat of serious physical harm to officers or others. And the ruling deemed that the Tennessee fleeing felon statute was unconstitutional, declaring that killing a fleeing suspect just to prevent his escape is an unreasonable seizure if they are unarmed and not dangerous. So this goes to a good example. If you're a police officer, again, you have a duty to act, right? You know you have, earlier in your shift, been given information about a rapist who has gone out and hurt many people. Rape is a serious physical harm that happens to people. People die from rape, right? So you have information about a suspect. It gives you that he goes out at nighttime, breaks into people's apartments in their alleyway, and he looks like this. He's about this tall, and you're on the lookout. You're patrolling your area, and you go down an alley, and you hear somebody screaming for help. Help, help, help. Someone just raped me. And you see somebody jump down off the back of an apartment building from the fire escape, and they start running away. And there's a warrant for this person's arrest. And this person matches that description. You as an officer have to make that decision. What are you going to do here? So if this is a felon, right? Rape is a felon. They are escaping. Does this felon who's escaping pose an immediate threat of serious physical harm to officers or others? That's a question you as the officer kind of have to figure out. If you let him go and he rapes another person, like what if he jumps into the next house and rapes somebody else and then rapes somebody else and kills somebody? Are you as an officer not doing your job when you are supposed to stop that felon and you are authorized by the Supreme Court that says, yes, you can use deadly force to prevent the escape of a suspected felon. You have probable cause to believe that this is a felon. Put all of the facts together. You have someone yelling, help, someone raped me. You see a person jump down off the fire escape. They run, they match the description. That is pretty good probable cause. You don't need to be 100% perfect in your assessment, but you've got the probable cause. So you as an officer have to make that decision. Now, I don't want to be in that position. I don't think most officers want to be in that position, right? Because you let the guy go and he hurt somebody else and you could have stopped him. You didn't really do your job. However, if he's not the right guy, yeah, that's not what your job really is either, right? But the Supreme Court and policies allow for mistakes. We might not like that as civilians, but constitutionally, we have to have certain levels of belief. We don't ever have to be 100% certain. When somebody pulls something out of their pocket and points it at an officer, and the officer has a split second to decide, and it says, the officer says, that looked like a gun to me. I think he's about to shoot me. The officer says, hey, you know what? I'm going to wait for that thing to shoot me first and kill me before I react. That's not a good response, right? The officer has to put everything together and decide, was that reasonable for me to believe that somebody pointing this black object, pulling something out of their pocket really quickly and pointing it to my head, even if that was a joke from that person, I don't know that. I don't know it's a joke until afterwards. At that time, this is what I know. Is that reasonable? And the courts will look at that. The investigations will look at that. But we now know Graham. We now know a little bit more about this Tennessee versus Garner. So here's a little bit more. If the suspect threatens the officer with a weapon, or there is probable cause to believe that he's committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used if necessary to prevent escape. And if where feasible, warning has been given. So that's that scenario I just gave you there, right? So the court is saying that if there's a crime that's been committed involving the infliction or threatened infliction of serious bodily harm, that's rape, right? Deadly force may be used if necessary to prevent that escape. And we should, if feasible, give some kind of warning instead of just shooting him, saying, hey, stop, police. But there could be times when a warning isn't really appropriate. If you are a police officer patrolling an airport and you see somebody with an AK-47 at the airport pointing up at airplanes, or they have a bazooka there and you yell, hey, stop, don't shoot that bazooka at that plane they're aiming at, the chances are he's going to get that bazooka fired before you get off a round. So in that case, I mean, this may be more of an extreme case, right? But a warning may not always be necessary. It's where feasible, the court says. So when you hear like, why did the officer give a warning? It's when it's feasible, not required. And a warning adds to that reasonableness of any force option, but it's not always feasible. So the officer yelling, stop, stop, police, and the person keeps running, does that make that person seem even more likely that they're going to get away? And I need to prevent that escape. They were not willing to stop for me. And again, remember in Graham, the officer was going to be judged from the perspective of a reasonable officer on the scene, not some expert afterwards, not some citizen that doesn't like this, not the family. It's what a reasonable officer would do at the scene. So again, we have these bedrock cases, Graham versus Connor, objective reasonableness. We have this foundational case, Tennessee versus Garner. And this is even reinforced again in Scott versus Harris in 2007. So a little bit more recent. If you're saying, hey, these laws are kind of old. Yeah, they've been around for a while. We've been using them for a while now. But in 2007, in this case involving a high-speed chase of a car, the court doubled down on the idea that there is no magic checklist. At the time, Justice Scalia, writing for the majority, noted that there is no easy formula for determining when force is excessive. Instead, courts must still perform the slashing balancing act, weighing the risk of bodily harm to the suspect against the threat the suspect poses to the public. This reaffirmed that the entirety of the situation, not just the one single factor, governs the outcome. So we talked about constitution, right? These are the cases that define what an officer can do. And as a police officer, most officers don't go through college. They don't sit in classes like this all the time. But most police departments, I would even probably guess all police departments, are required to have their officers do use of force training at least once a year. When I was a police officer, we had to do it twice a year, around the same time when we would qualify with our weapons to make sure we could shoot well enough to not miss our targets. But again, we didn't have to be perfect. We had to be pretty good. I think we had to score about 80%. So, think about if you're just taking a test, 80% is not the best in the world. It's not bad, but I had to pass with at least 80% to be proficient, to keep my gun and to keep my job. But all of that information, police are trained at police academies, maybe in a few hours, right? But they look at a policy. There's a policy written by their department. Maybe the state determines how it should be. There's this national consensus policy on the use of force, which I shared a moment ago in the beginning. This is what it looks like. It's not that long. It has a purpose. It has what the policy is, and it's just 4 little paragraphs there, some definitions. And one of the definitions, when we say deadly force is any use of force that creates a substantial risk of causing death or serious bodily injury. So when we're saying, well, why did the officer use deadly force? Deadly force doesn't mean that the person died. It means that the force that the officer used creates a substantial risk of causing death or serious bodily injury. So when an officer is shooting at somebody, that's deadly force. Whether we want the person to die or not, and we're not always trying to get someone to die, we'll talk about that in a few moments, but we're trying to get that threat to stop. But if I shoot at somebody, there is a substantial risk of causing them to die or to give them some kind of serious bodily injury, right? So that is what deadly force is. The person doesn't have to die for it to be deadly force. If I have a baton and someone's beating the crap out of me, trying to take my gun from me, I've been fighting this person for 10 minutes and there's backup is not coming anytime soon, and I'm afraid they're going to kill me, and I all I have is my baton, and I take my baton and I hit this person in the head repeatedly, yeah, that's me using deadly force. It wasn't a gun, but hitting somebody with a metal pipe on their head, that creates a substantial risk of causing death or serious bodily injury. So I'm filling out a use of force report saying I employed deadly force by striking this person with my baton on his head. Now, if I didn't want to use deadly force, I'm striking him in other places, like his arm, his legs, in places that will cause pain to get him to stop. But if I think that I'm going to die in all this, I'm going to use deadly force to stop that threat. Then it goes on a little bit further, and it has some procedures. It talks about de-escalation. It talks about use of less lethal force. It talks about the use of deadly force. And then it goes on, and this is the last page. So it's 3 pages. And part of it is talking about, yeah, officers need to receive this training at least annually. But it says there are some restrictions, right? Deadly force restrictions. Deadly force should not be used against persons whose actions are a threat only to themselves or property. So this goes to those mental health type incidents, right? And if the person just wants to hurt themselves, we shouldn't be like, yeah, I'll help you. You want to shoot yourself? Yeah, let me shoot you to stop the threat. Because you're threatening yourself. That should not be. But if the threat moves to other people. And I also cannot use deadly force against property. So a person is bashing all the windows of a house. I can't shoot them. As a police officer, I can't protect property by trying to use deadly force against them. Of course, I could tackle them. I could punch them. I could hit them with a baton. I could use OC spray. I can use a taser. And also recognize it's depending on what tools are available to officers. When I worked in New Jersey for many, many years, tasers were not available to officers. Tasers were actually considered deadly force because the law was written in New Jersey well before tasers ever came into existence. And it said anything propelled out of a weapon that goes under the skin of somebody, that is considered deadly force. Well, a taser will go into your skin. The little probe goes into your skin. So New Jersey, it was not allowed legally to use tasers because that was deadly force. I think the laws have changed now. I think officers start having tasers, but tasers were around for many, many years. And I didn't have that available to me. I had a baton, I had pepper spray, and also warning shots. I hear people talking about it all the time, like warning shots. We should just give them a warning shot. Well, that bullet's going someplace, right? This national consensus policy does say that warning shots could be used. So you could adopt that for your policy for your department. However, it's pretty dangerous that a warning shot must have a defined target and shall not be fired unless also the use of deadly force is justified. So I can't just say, oh, you're breaking some windows, I'm going to shoot in the air, right? I've got to have some defined place I'm shooting it. So in the air is probably not the best place because that bullet's got to come down someplace and hit somebody. So I'm already justified to use deadly force here if I want to use some type of warning shot. It should not pose a substantial risk of injury or death to the officer or to others. And the officer reasonably believes that the warning shot is going to reduce that possibility that deadly force will have to be used. Those are a lot of considerations to have. And in split-second decisions, officers are going, okay, well, I know I can use deadly force here, but am I going to hurt somebody else? Am I going to miss? Is that going to stop him? If he's got a gun out and I think he's going to shoot me, but if I just do a warning shot, what if he doesn't drop the gun? He's probably going to get a shot off before I get my second shot off. Am I going to die before I do that because I'm shooting a warning shot? Should I just shoot him instead? Those are things that officers are thinking about. So I don't know how often warning shots are really being used. And again, a lot of departments don't allow that because you should only be shooting at the target of the person you need to use deadly force because that bullet is going someplace. And also, this is a big thing we're going to get into in a second here. Firearms shall not be discharged at moving vehicles unless A, the person in the vehicle is threatening the officer or another person with deadly force by means other than that vehicle, or the vehicle is operated in a manner deliberately intended to strike an officer or another person, and all other reasonable means of defense have been exhausted or are not even present or they're not practical, and which includes moving out of the path of the way of the vehicle, right? Firearms shall not be discharged from a moving vehicle except in exigent circumstances. So cops shouldn't be driving down the street shooting with his hand out the window unless it's such a crazy incident. And I've seen videos where there's suspects firing at police officers as they're driving, and the officer can safely return fire, or the cars are stopped and the officer has to shoot through his windshield to protect himself or other people to stop the threat, and often it is effective. So that would be allowed there. But we've seen these incidents where, especially Renee Good was shot by ICE agents, and we would have to look, what is the policy of that agency? We have to look at the Graham factors, right? We have to look at Tennessee versus Gardner. Those are the things we need to look at if we're analyzing this. Not just that we think it's wrong. We can definitely think it's wrong as civilians. We don't like that the police shot this person. And in the end, it may be completely unreasonable. It may be excessive. It may be illegal. It may be murder. But that's not for us as civilians to decide that. And we may not have trust in certain people who are investigating it, right? There's a lot of issues that go into this, right? But this is what is supposed to happen. It isn't always what happens. But when things go in front of the courts, usually the courts will sort it out to the best of their ability. When there's lawsuits and stuff, but officers don't want to be sued. Departments don't want to be sued. Cities don't want to be sued. So it's in their best interest to have a good policy that reflects the law. Most departments have police legal advisors working for them that are saying, this is what the law is. This is what has changed recently. This is what we need to do to train our officers. Oh my gosh, this just happened. We need to better train our officers so we prevent that from happening again. Or it happened in another jurisdiction. We don't want it to happen here. So really, really important that we get our policy right and we train our officers on that policy and that we help them make good decisions and use de-escalation when necessary and appropriate. And they use other tools besides just their gun. To understand where we are in 2026, we have to look at how the Supreme Court recently corrected a long-standing legal shortcut. For years, many jurisdictions used what we called the moment of threat doctrine. Under that rule, if an officer was in immediate danger at the exact second they pulled the trigger, the use of force was almost always ruled objectively reasonable. It didn't matter how the officer got there. It only mattered what happened in that final blink of an eye. Well, in the case we're going to look at in a moment, the court clarified that the Fourth Amendment requires a totality of the circumstances review. So what does that mean in practice? It means we are no longer allowed to put on these like legal blinders. We have to look at the pre-event conduct as well, not just that what happened in that quick second there. We have to ask, did the officer's own actions unnecessarily escalate, or tactical errors there create a very danger that eventually they had to respond to? And was the approach consistent with training and policy leading up to that encounter? Think about back to these ICE encounters and the protest footage we've seen recently. Under that old moment of threat rule, a legal advisor would only look at the frame where the threat appeared. That moment that here Renee Good steps on the gas. Under Barnes versus Felix, we're now required to hit rewind. We look at the deployment, the communication, and the tactical positioning. We're going to look at everything, the totality of the circumstances. Right? So when did it all happen? And we're going to use everything. Even this last photograph here, we have obviously a video, but where is this shot being taken from? It looks like he's still shooting as the car is getting away. So now does this turn into a fleeing felon? So let's say he never shot her, never made contact with her, never shot her until the car starts pulling away, which is what we see in this last picture here. Does he have the right under the law, under this fleeing felon kind of concept? What type of threat was she? What type of crime did she commit? Did he have the authorization under the Constitution and his policies to shoot? And again, his department may say, you cannot shoot at moving vehicles. I remember when I was a police officer, my policy in my department was we were not to shoot at moving vehicles. And if we got in the front of a moving vehicle, we better move away. We should not be jumping in front of it. And I think there's a good argument here to say, did this officer really put himself in that position? We saw them chatting with Renee Good. She didn't seem to be a threat. I'm not going to give you the answer here because that's not my job. That's not any other people in this call's job. It is the investigations and the courts to decide whether there was excessive force, whether there's even murder here, whether there was violations of policy, whether there was violations of the Constitution where rights violated. But that's the type of conversation that they're having, right? It's this Graham factors. It's Tennessee versus Garner. It's this totality of the circumstances. It's not just, hey, we don't like what the video shows. We don't like this. We don't like where he was standing. We don't like that she died. Yeah, every incident where someone dies in the hands of police is horrific and should never happen if we can prevent it. But sometimes it's necessary. Sometimes it's legal to do. Sometimes we want the officer to do that to stop a horrible, horrible threat. In this incident, I don't know. I'm not going to give you my full opinion here. We don't know what was going through the officer's mind. We see some video footage. We only got some snippets the first couple days. Then more video showed up later that showed maybe he was hit by the car. But we also can see in that picture on the bottom left that he's kind of standing to the side of the car, not in front of it when he's shooting. But was he standing in front of it and not able to move out of the time? Again, we're not supposed to be looking at it from 2020 hindsight. Oh, he should have done this better, but we need to look at the totality of the circumstances. What would a reasonable officer in his shoes at that scene do? Not what a reasonable officer do sitting at a police desk as a commander or a legal advisor. What would they do? What would a reasonable officer making split-second decisions, what would they do? That's what we're asking here. So again, those same factors, same exact factors we talked about earlier is what we're talking about here. I'm not going to go through them all again. We kind of talked about some of this stuff, right? All right, I'm going to show you this video. This is Barnes versus Felix. This is pretty quick. The incident really happens in a quick little blip here. So keep an eye out on it. Yeah, we'll talk about it in a second.
two outstanding tow violations. You have your driver's license and proof of insurance with you? Sir? I understand that, but it has outstanding tow violations. When did you rent the vehicle?
About a week ago.
About a week ago?
It's actually rented my girlfriend's name. I'm actually on the way to do it.
I'm sorry, I couldn't hear you.
It's actually rented in my girlfriend's name. I'm on the way to get it washed and turn it back in.
Okay. What's her name? Okay. You have your driver's license? Anything this vehicle I need to know about? Okay. I'll go digging around. I smell marijuana. Is there any marijuana in the vehicle? Don't dig around. Don't dig around. Don't dig around. Okay. So you don't have anything, any identification on you? Okay. Sure, go ahead and pop the truck for me. Okay. So go ahead and put that paper off to the side for me. Go ahead and step out for me. Don't fucking move! Don't fucking move! Watch out, 14, shots fired! Shots fired! Let the shots fire! Let the shots fire! I think that's HFD now!
So what happened here? This was April 28th, 2016. Officer Roberto Felix Jr. pulls over Ashton Barnes after learning that Barnes' Toyota Corolla was associated with outstanding toll violations. Officer Felix contacted Barnes at the driver's side window. Officer Felix smells marijuana at some point as Barnes starts rummaging around through some papers inside the vehicle. Barnes said his driver's license may be in the trunk, and at Officer Felix's request, he opens the trunk and turns the car off. Officer Felix asked Barnes to step out of the car. Barnes opened the door but remained in the car. He turns the car back on and starts to drive forward. As Barnes drove forward, Officer Felix drew his firearm and jumped onto the sill of the open car door. About 2 seconds later, Felix fired 2 rounds in the driver's compartment of the moving vehicle, and he kills Barnes. The district court defined the relevant moment of threat as the 2 seconds that elapsed between Officer Felix jumping onto the door sill and firing the first shot. The district court concluded that Officer Felix was at risk of serious harm during those 2 seconds. Therefore, he was justified in using deadly force. And then it goes to the Fifth Circuit Court, and that court says, yep, we're looking at the moment of threat, those 2 seconds that the officer is on that car. What is he going to do? The car is moving. The car might be getting into traffic. He's going to die. The officer, it's reasonable for him to use deadly force to stop that threat from the officer dying. So again, the district court and then the Fifth Circuit actually has some comments on it, right? So this moment of threat or the totality of circumstances, which one comes into play here, right? Under the moment of threat test applied by the Fifth Circuit, the reasonableness of deadly force was determined based only on the circumstances of that moment immediately preceding the use of force. In this case, those 2 seconds. The moment of danger, moment of threat approach, the U.S. Court of Appeals for the Fifth Circuit explains the excessive force inquiry is confined to whether the officers or other persons were in danger at that moment of the threat. And the focus of the inquiry should be on the act that led the officer to discharge his weapon. The U.S. Court of Appeals actually has been split on what actually should happen. We have the Fifth Circuit, along with the Second, Fourth, and Eighth Circuits, employs this moment of threat test, while the First, the Third, the Sixth, the Seventh, the Ninth, 10th, 11th, and the D.C. circuits. So there's several appeal-level district circuit courts in the United States. So after each district court, you go to a circuit court, and these circuit courts are split. Some say it's the moment of threat. Some say it's the totality of circumstances. Well, the Supreme Court now gets the case and resolves the disagreement in Barnes versus Felix. Under the Barnes decision, all courts, the Supreme Court says, must assess the totality of the circumstances without limitation as to the time to include relevant events leading up to the use of force. The court expressly did not decide any kind of separate question of whether or how an officer's own creation of a dangerous situation factors into the reasonableness analysis. So the Supreme Court here doesn't decide in favor of one or the other. It just says, hey, courts, you can't use this moment of time. You have to look at the totality of circumstances. And did that officer create that danger? What happened beforehand? And the courts might end up saying, well, when we look at it, we still think that it was reasonable. But again, we need to look at some of these things in terms of, should the officer be firing at a moving car? But is this an exigent circumstance where the officer's on this car and there's no way to stop it but to shoot this person? You know, if he kind of leans back, is he going to fall on the street and get run over by the car? Is he going to fall out and get hurt? Those are all questions to be asked. But also, what happened beforehand? And this should go to policies, and decision making. Was it smart for this officer to jump on a car like this? He knew who this person was. They have his license plate. It was for toll violations. Should the officer, should just let him drive away and chase him down? Those are all good questions to have, right? But that's not what we're really asking here. The court is just determining in Barnes versus Felix that we've got to look at it differently. We have to look at the totality of the circumstances. That's what we need to do. So the SCOTUS case and all these cases are going to talk about underscore that the constitutional reasonableness of force must be evaluated based on all relevant facts and circumstances, not limited to that moment it was used, or tainted by unrelated constitutional missteps. So we already kind of looked at these pictures, right? So while Barnes versus Felix reaffirms the constitutional Fourth Amendment standard of objective reasonableness on the totality of the circumstances for any type of force, it's interesting to know, right? California has its own additional statutory standard for deadly force. Some other states have their own statutory standard for deadly force. In California, deadly force may only be used when the officer reasonably believes it's necessary to defend it against an imminent threat of death or serious bodily injury. And imminent is an interesting word. It is not immediate. Immediate means it's going to happen in like that second. Imminent means it's going to happen in that second or sometime in the near future. If someone has a gun at their side, it's an imminent threat that within a few seconds, half a second, 2 seconds, that gun could be raised at an officer. That's when we're looking at imminency and not immediacy. The statute also requires officers use available de-escalation tactics and consider less lethal alternatives when reasonably safe and feasible. Sorry, got behind here a little bit on the slides. But agencies must ensure that their use of force policies and internal reviews comply with both federal and state standards. So the left here, that's New Jersey use of force policy thing. There is a use of force policy handbook for for U.S. Customs and Border Protection. There's another model use of force policy from the Washington State Office of the Attorney General. So again, each in Washington State, either it's the counties or the individual departments are going to create their own policy. But the State Attorney General's office is like, well, here's the model. This is what we'd like you to use. And it could be called into question, right? Department, why are you not using what the state says as the model? Well, the state isn't demanding you have to do it. It's saying, this is a model. We'd like you to use this. But some states don't prescribe what it should be. It's the department who's determining it because, again, there could be differences from department to department. So as we finish up here, what could be happening? What could we look at besides just policy and the Supreme Court of the United States, right? Well, the Congress, they could be passing laws if they did. There was legislation that passed just the House back in 2020 that would have limited the use of deadly force by federal officers to a standard of necessity under the totality of the circumstances, saying the totality of circumstances, they defined it as all credible facts leading up to and at the time of the use of force. It could go beyond the existing Fourth Amendment baseline for permissible uses of force, but it could contravene what the judiciary says and face possible legal challenges. It may limit particular uses of force that could pose administrative things, administratability and enforcement hurdles and practical challenges where we're telling officers now they got to think in a different way and they can only use it here. And if this happens first, this Again, they're making split-second decisions, so there could be hurdles. Not saying that's impossible to do, right? But there could be hurdles. Congress might also consider addressing existing civil enforcement mechanisms and the judicially created legal doctrine of qualified immunity, which generally shields government officials, including law enforcement, from civil liability based upon alleged deprivations of statutory or constitutional rights under certain circumstances. They could eliminate qualified immunity for claims brought under Section 1983. And then Congress could leave the resolution just saying, we're going to leave these legal issues related to police force to the courts. We're just going to let the courts kind of handle it, which it seems like they're doing today. So part of my final thoughts, is that deadly force when an officer pulls out their firearm or points it at somebody? It's usually not. It's when they pull that trigger. This is creating a constructive authority. It is a threat that I may use force, but this is not considered deadly force under the law, under policies, under the Supreme Court, that it may be necessary, the court even said, to have a threat of force being used to do some type of detention, some type of seizure. So it could be reasonable in circumstances. Again, it has to be reasonable. So it could be reasonable under circumstances to point your gun at somebody as a police officer to get them to stop, to get them to comply. It may be very unreasonable at times to do so. And I hear these questions, all the time. As a law enforcement officer, as a police legal advisor, as a professor, these are the two most frequent questions in criminal justice discussions, and they often come from a place really of genuine concern about the loss of life, right? We're concerned about the loss of life. So let's have this conversation, but we're going to shift it from intent to mechanics and probability. So first, why do officers shoot to kill? Law enforcement training actually teaches officers to shoot to stop the threat. We don't train shoot to kill. Our intention isn't to kill somebody. That may result from shooting somebody, shooting anybody with a bullet. Hitting someone over the head with a baton could kill them. We're trying to stop the threat. So policies, training are about stopping the threat. So why is the officer shooting 4 or 5 or 6 times? To stop the threat. And that very first video we saw, officers fired on this guy as he's walking away, shooting with the gun behind him. He's facing away. They shot him in the back. And I've heard people say, you can never shoot someone in the back. Well, that's a great example of why you're going to shoot somebody in the back. That person was walking away with the gun pointed behind them, still shooting at officers, posing a very big threat to everybody at the scene, officers and bystanders at this store that they're at, or gas station, wherever they're at. So the officer shot many, many times. It took him a while to go down. He was shot several times. So it's not, let's just shoot once and see what happens. You're going to shoot until that threat is stopped. While the result is often fatal, the objective is the immediate neutralization of life-threatening action. We don't want it to be let's just see what happens here. We want to stop that threat. Also, center mass. Officers are trained to aim at the largest part of the body, the torso, the major center mass. Under extreme stress of a lethal encounter, fine motor skills actually degrade. Aiming for the largest target increases the probability of hitting the suspect and stopping their ability to continue a deadly attack. If we're aiming for a finger or an arm, we might miss and shoot somebody else. We want to stop that threat so nobody else dies. If I, as an officer, only wound that person and he's still able to shoot, he might kill me. Well, now he's loose with his gun, killing other people, and you don't have that police officer to stop that threat, right? So it's immediate stopping of that threat. I'm going to shoot for center mass. We want that stop requirement to stop a person immediately, especially one who may be under the influence of substances or even in a high adrenaline situation where the off switch, the nervous system or major organs is located in that torso. So that's where we're shooting. And why don't they just shoot them in the knee? This is a Hollywood myth. In reality, aiming for limbs is tactically and legally problematic for several reasons. First, the difficulty of the target. Hands and legs are small, they move rapidly, and are notoriously difficult to hit in a high-stress, dynamic environment. Even expert marksmen struggle to hit a moving limb when their own heart rate is at 150 beats per minute. And there's a risk of ricochet and overshoot. If an officer misses a small target like a leg, the bullet continues until it hits something else, potentially a bystander or a fellow officer. And in an urban environment, skipping a bullet off the pavement by aiming low is a significant liability. And lethality still remains high, right? The human leg contains the femoral artery. A gunshot wound there can cause a person to bleed out in minutes. People die from one single gunshot wound, no matter where they get hit. Shooting the leg is not guaranteed a non-lethal alternative. It is still use of a deadly force. And also the legal threshold. Legally, a firearm is defined as deadly force. If the situation has escalated to the point where an officer is legally justified in pulling the trigger, the law assumes that a threat to life already exists. Attempting some kind of trick shot suggests the threat might not have been serious enough to warrant deadly force in the first place. And there is so much we could talk about. This was an hour and a half, just barely an hour and a half. This could be a 40-hour course, if not more. We didn't really talk anything about constructive authority or physical force or less lethal force or even de-escalation. We didn't talk about decision-making. We didn't talk about tactics. There was so much to think about. So with hearing all of this tonight, I'm hoping that you are better to speak to analyze, to listen to folks, and to examine police use of force encounters. You have the terminology now, you have the understanding. So you're going to think a little bit smarter as you look through this. We may still believe that it was a bad shooting. It still may be a horrible incident, but we need to look at it at the lens of what is legally allowed. And if we don't like that, what we can do is, yes, we can protest. We can get different people elected into office to change the laws. People can file lawsuits, right? There are things that we can do to change things. So as an advocate to reform the justice system, there's things we can do. If you get into leadership positions, you could change your policy for your department. You have to be careful that you're not putting your officers in jeopardy. You're not putting the public in jeopardy by restraining too much where, again, that rape suspect gets out. I don't know that happens too often where people are shooting at someone in the back as they're running away. Legally, we might be allowed to do it. Policy-wise, we may say no. Morally, we may say no. Police officer morally may say, in my judgment, I'm not going to take that shot. I don't know that that's the exact person. I'm going to take my chances maybe that I can tackle him. Another officer can get him. If I have a taser, I can shoot him. There's better technology nowadays. We might be able to get our dog out there to chase him. We may be able to get a drone to chase him. There's other things we might be able to do. But there are things that we can do, but there's also what the law is. And we may be very upset with a Supreme Court decision, with an investigation, with political statement. But it doesn't mean that it's the act of that deadly force was unconstitutional. It doesn't mean that it was excessive. We may not like it, but we have to look at the law when we analyze this stuff. So thank you so much for attending day 3. We have a few minutes. I'm going to stop sharing my screen. I will see if there's any questions I can answer, if folks have anything. But I hope you enjoyed this. I'm seeing Heather asking about the reasonable officer. So again, reasonable is of what other officers in that position would look like. It is the court that is judging that, but they are usually experts that get on the stand that talk about what is the training, what are officers trained to do, how are they use their weapons. All of those things go into what's reasonable. The defense may put some marksman on and say, in this situation, I could have been with my gun and I could have done some trick shot and got this guy and not killed him and just knocked off his pinky. Again, that's not reasonable, right? That's not what a reasonable officer can do. Yeah, and depending on someone who's neurotypical or neurodivergent, it could be different, yeah. But we're going to base it upon not that individual, but based upon a reasonable officer with the type of training that officer has. If the shooting happens in New Orleans, we're not going to compare that New Orleans officer with a LAPD officer who may have been in 20 shootings in their lifetime because they are in a very, very bad neighborhood and they did a lot of shootings, who might have some better knowledge and better training than someone who's been on the job for a couple of days. We're gonna compare them to a reasonable officer in that department and what their training is through. I see that question. Do federal agents like ICE receive different training compared to city and county police? Yeah, absolutely. Most federal agencies, they're not training their officers to be frontline officers on the road to act in these situations. Most of them are not trained to do regular policing work, to pull cars over, to interact with drivers. They're usually at the criminal investigator level. They're trained at a little bit higher level, if you could say, like really responding to scenes after the fact of a crime. We do see ICE agents going in and arresting people who have warrants or they believe they have probable cause to arrest them. Their training is going to be different, but their policies for use of force still have to be the same. But they may not be put into situations where, what do you do when someone doesn't move out of the way in their car, where Renee Good is? I bet you those officers didn't have any kind of training about how to deal with someone sitting in their car not moving. Their training was probably all about, what if somebody doesn't want to comply, who's under arrest in their house, or they're chasing them down because they're someone who needs to be deported. Their training's going to look a little bit different, and every department could be a little bit different too, but they still have to comply with the Constitution. Yeah, many departments, it could just be 18 years old and a high school diploma to get a job. For folks who studied criminal justice, may remember the father of American policing, August Vollmer, where he pushed for professionalism in policing. He believed in people getting college educations. And for a while, many police departments did require college education or community college education or so many credits, because just going through the academy at 18 years old and making a split decision about taking someone's life is hard, challenging, and maybe not the best for someone whose brain is still developing. I advocate for officers to be going and getting their 4-year degree, studying the law, getting continuing education. But we also have a problem where a lot of folks don't want to be police officers nowadays. So we have a reduction in the requirements to get more people in. So folks watching this, I think there's nothing more noble than serving your community. I did that as a law enforcement officer. Many folks maybe on this call did too, where this is about helping your community and being that next generation leader. We heard from Chief Jokerst last night. She moved up from a regular patrol officer all the way up to chief, and she's instituting change. If we want to be that change, we've got to get into these jobs and make those changes. Same with the military. Yeah, you're right. Someone's asking, what's the difference between criminology and clinical psychology? So criminology is the study of crime. So we're looking at a lot of criminological theories of why we believe crime happens. We have a lot of research and evidence that says this is why people commit crime. It may be environmental factors. It could be psychological things. Is it a brain tumor in their head that made them do this? Is it the way they were brought up? Were they abused before? So there's a lot of psychology that comes into this, into criminology studies, but the environment, stress, people who are trying to live the American dream, people maybe who are labeled criminal, believe that they're criminal, so they continue to do criminal acts. There's a whole course and many, many courses where we talk about the why. Why do people commit crime? That's what criminology is. And that's different than a lot of places who study criminal justice. Criminal justice programs do study a lot of that, but a lot of criminal justice programs study also, like, what are the functions of police? What does the court look like? How does everything work together as the system? Usually criminology programs don't focus as much about the system. We absolutely have to talk about the system. We do touch on it, but we're talking more about the why. It's a little bit more focus on that. And then clinical psychology is specific to the psychology of that person, how they operate, their behaviors, and it's in that clinical way of looking at it. There's also forensic psychology about looking at the psychology in the legal aspects, and that's what Dr. Jason Meadows did earlier today. So clinical psychology is not going to get into really much about criminological theories in crime. It's going to look at, someone's using substance abuse or has some mental health condition. How does that affect their behaviors, and what can we do to maybe treat them? It's usually about treatment and not about enforcement and crimes. Yeah, we could stay for another 5 hours to talk about this. I so appreciate everyone for coming out tonight. Thank you for joining us. I hope to see you tomorrow night for the last bit of our event, and then when we do this again next year. So good night, everyone. Talk to you soon.